Good afternoon, everyone. My name is John Cornwell, and I'm the Director of Marketing and Business Development here at Plunkett Cooney. It's my pleasure to serve as coordinator for today's webinar. So let me begin by welcoming everybody. We certainly appreciate you taking time out during this difficult period. We hope you're all doing well, and it's good to see you're on the line and business is still proceeding. And so I want to just mention that today's program, as you know, is going to focus on some fundamental changes, some real different changes to civil procedure in our Michigan court rules that we're pleased to tell you about today. And that's why I'm really happy to have Rick Simchek and Kate Neiswander on the line here today. They're from our Torts and Litigation Practice Group, and they're going to help cut through the clutter and tell you exactly what you need to know about these important changes. Before we get started, though, I just want to take a couple minutes here to tell you a little bit about our firm for those that maybe don't know. Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and most accomplished law firms. And we have about 140 attorneys and 7 offices in Michigan. We also have offices in Columbus, Ohio, Chicago, Illinois, and Indianapolis, Indiana. Our Tort and Litigation Practice Group is comprised of attorneys from across the region who focus their practice on various aspects of general liability, retail liability, premises liability, dram shop, food service liability, and other areas of litigation. They routinely defend the interests of retailers, food service and hospitality establishments, commercial property owners, and other businesses insured by some of the world's leading insurance providers. With me, again, as I previously mentioned, are Kate Neiswander and Rick Simchek, and both of them work in our Bloomfield Hills office. Rick has been practicing law for about 42 years now, and he manages a diverse litigation practice that includes premises liability, insurance coverage, motor vehicle liability, title insurance, and even banking law. Rick works closely with clients, including self-insured and policyholders of insurance carriers, to resolve complex and high-exposure matters. He's a member of the Michigan State Bar of Michigan, our Genesee County Bar Association, and DRI. For those that don't know what DRI is, it's formerly the Defense Research Institute. And Kate has a way to go to catch Rick in terms of length of service, but she's been practicing for nearly a decade herself. She's also a member of our tort litigation group and serves as defense panel counsel to some of the nation's leading insurance providers and on behalf of their policy holders. Kate has particular expertise in the areas of premises liability, auto and no-fault law, dram shop disputes, and food-related claims. She's a member of the Oakland County Bar Association and the State Bar of Michigan. Before we get started, I've been asked to cover just a couple housekeeping notes about today's program. At the end of the webinar, we're going to take as many questions as time permits. If you would like to ask a question, simply type it into the questions queue in your GoToWebinar display. Those questions will be there, and at the end, I'll come back on the line and read through those for our presenters. Once again, on behalf of the firm, thank you for attending today's webinar. Now let's get things started. Rick, I believe you're up first, so tell us what's going on with Michigan's new court rules.
I am up first. John, if you would, let's go to the first slide, MCR 1.105. Before we really start, I do want to echo John's comments. Thank you all for joining us during this very busy and uncertain period. We will make this a valuable experience for you. We go to MCR 1.105 because in all the seminars put on by the various legal organizations, bar associations in Michigan, they've all started with this rule as a mission statement for what the new court rules are going to be, with the emphasis on just, speedy, and economical as the concepts which are going to be honored and served by these changes. Now, that's the espoused reason for these changes. While that's the announced motivation, there is going to be some conflict because the law of unintended consequences is just as true in court rules as it is anywhere else in life. And the potential conflict between what the mission statement is and how, in fact, these new rules are going to be implemented. Now, in doing this, we have quite a number of rules. We're going to try and cover this with as much depth as we can in the 50 minutes that we're going to borrow from you. and try and give you as good an overview as we can of these changes, primarily in the area of discovery. We're going to talk about initial disclosures, a concept that's new to Michigan court rules, not so new in federal court, but we'll talk about that in considerable detail as to what's really going to be expected and how much that front loads discovery. With regard to depositions, interestingly, we've come up with a new concept of limitations on time, 7 hours in one day, which will test the patience of every lawyer who has to depose expert witnesses or handles employment cases. Different ruling on interrogatories, a different rule for interrogatories. We are now limited to just 20 interrogatories, which will, of course, change that dynamic considerably. Discovery plans are another new concept, not so new in complex litigation or in federal courts, but new to the Michigan court rules. A new method to handle discovery disputes and some very explicit rules with regard to electronically stored information, now known by the acronym ESI. And with that, I turn it over to Kate.
Now, with respect to initial disclosures, it's important to outline their specific requirements as well as the timing. Now, parties are only required to disclose initial disclosures in circuit court cases unless ordered in district court cases. Now, initial disclosures are to be exchanged before depositions or any other written discovery is permitted. With respect to the actual submission of these initial disclosures, the plaintiff is required to file his or her initial disclosures 14 days after defendants file an answer to the complaint, and defendants are to provide their initial disclosures either 14 days after plaintiff's initial disclosures are filed or 28 days after filing their answers. And this comes down to whichever is later. Now, with respect to parties that are later added to the case, they must provide their initial disclosures 14 days after filing their answer to the complaint. So this puts later added parties in a worse position because they don't have the extra 14 days to actually compile their initial disclosures. Now, with respect to the actual content of the initial disclosures, all parties must provide a document that contains the following information: the factual basis of the defenses or claims. So in this case would be our defenses. If we are relying upon the open and obvious danger doctrine, you have to put forth factual basis to rely upon that defense. The second requirement is legal theories in which the defense is relying upon, or the legal theories that the plaintiff is relying upon. Usually these are already outlined in a plaintiff's complaint, but with respect to defendants, we now have to outline in more detail the legal theories that we will rely upon. And this also includes any citations to relevant legal authorities. The third requirement is the disclosure of witnesses. So this is the name, addresses, and telephone numbers of all known witnesses likely to have discoverable information. We also have to provide the subject of these witnesses' anticipated testimony, and this also kind of has, there's one little caveat or exclusion that you don't have to disclose witnesses solely used for impeachment purposes. So we don't have to disclose experts or surveillance witnesses if they're only going to be used for impeachment purposes. Now, the fourth requirement are documents in possession of the defendant or the plaintiff. Now, we can either produce a copy or a description by category and location of all documents, ESI, which Rick will discuss later on, tangible things that are in the possession and may be used to support the defense of the case, unless the use would be solely for impeachment purposes. Now, I have a tendency just to list a description of the documents by category and location rather than producing them. There's nothing wrong with doing the opposite and actually producing the documents, I just prefer to provide a description by category and location and have the plaintiff take the action to request the production of those specific documents. A lot of times there's plaintiffs that are bogged down or handling something else at the time, or in fact, there's quite a few more lazy plaintiff attorneys that just don't take the time to conduct discovery. So in those cases, they may never request for the documents that are listed in this category of initial disclosures. And there's no need for us to take the extra work or put forth the extra work to produce those documents if we don't need to. The next category in initial disclosures is the documents that are not in our possession, but will likely be relied upon. Now, this is a new requirement outside of what's required by the federal rules. It requires defendants to provide a description by category and location and provide the likely custodian of these records, of any records that we anticipate that we will rely upon at trial. The only other exception is if they're used for impeachment purposes. So the documents that we have to list that someone else has possession of does not include those that we'll be using for impeachment purposes. The next category, John, if you go to the next slide, please. Actually, if you can go back, I apologize. The next category is damages. This only applies to plaintiff's attorneys. They have to actually provide the amount of each category that they're seeking to recover in their lawsuit. This is something different than is even required in the federal court rules. They also have to produce the documents, if requested, that they rely upon in support of the amount of damages that they're claiming. The next category for initial disclosures, and this one applies specifically to defendants, is production or a description of insurance documents, as well as indemnity documents, security equivalent documents, or agreements that may provide coverage for claims alleged by the plaintiff if they actually prove liability at trial. Now, this includes self-insured retention policies, limitations on available coverage, indemnity or reimbursement agreements. I have a tendency just to produce deck sheets at this point, unless I know that there's something at issue with the insurance policy in which the defense is being provided under a reservation of rights. So in most scenarios, it's an easy way to deal with it. Just say, see deck sheet in those types of scenarios. The next category is also the anticipated subject area of expert testimony. You don't have to specifically outline any specific experts that are called to testify, just the anticipated subject areas. Now, plaintiffs in personal injury suits are also required to provide signed authorizations for the release of their medical records unless they're asserting a privilege. And this has to be done with the submission of their initial disclosure. So this is 14 days after the defendant filed an answer to their complaint. Now, there's additional PIP, no-fault PIP disclosures. Now, in no-fault suits, the defendant is required to produce a copy of the claim file, privilege log, and payment log with their initial disclosures. Now, with respect to plaintiffs also have to produce the identity of all facilities and individuals who provided medical, household, and attendant services, all provider bills or outstanding balances in which they are seeking reimbursement, the names, addresses, and phone numbers of their employers, as well as the signed authorizations for the release of their medical records. John, if you could go to the next slide. There's
At
also
this point, I guess I'll step in and talk about the signature requirement, which is sort of new. This is the requirement that an attorney of record or a party in pro per must sign the disclosures and all the discovery responses and discovery requests. This is a departure from prior practice. Ordinarily, an attorney would only sign for objections in discovery responses. Often, attorneys would certainly sign the discovery requests, but it's never before been a requirement, both for the new requirement of disclosures, but the old issues of depositions on written questions, interrogatories, and responses to requests to produce, that the attorney sign. Now the attorney is signing the same way the party signs, essentially vouching for the accuracy of the discovery request, the discovery response. This is, again, new, different, and something that attorneys will have to be careful about as they go along. The consequences of not signing are significant. Unsigned disclosures or responses will be stricken. This could be very serious, obviously, in circumstances where you've got requests for admissions, where if the responses were stricken to those requests, they would essentially be unanswered and therefore deemed admitted. The additional consequence of not signing the disclosures or the discovery responses are that the other party need not take any action with respect to them until they're signed. Essentially, they don't exist until they're signed by the attorney as well as the party in those circumstances where both signatures are required. Again, this is significant. Nobody has to respond to a discovery request. Nobody has to respond to a request for admission or an interrogatory, or even file the responsive initial disclosures, a defendant for plaintiff, unless the other party and attorneys have signed those disclosures. Moving on to initial disclosures and supplementing disclosures, there's always been a technical duty to supplement under discovery under the Michigan rules. Now, in an attempt to clarify that, they've changed the rule, and it seems that it is both automatic and by request that one has a duty to supplement. The duty to supplement arises when the information that was previously disclosed is either insufficient, wrong, or has been altered by the addition of more information. It is hard to think of a case where discovery responses would be completely static. So this imposes a new burden on the parties to continually be conscious of their duty to supplement or suffer the consequences. If we can go to the next slide, those consequences can be significant in terms of the possibility of a motion to compel with sanctions, and those sanctions can be even to the extent of disqualifying witnesses, not allowing the use of witnesses or information at trial, unless it can be proven that the failure in this instance was harmless. Again, this is another imposition of a new and additional duty on the parties, and most specifically the attorneys in the litigation, to make sure that discovery responses are current in every way, shape, and form, or face the possibility of losing an important witness or an important piece of documentary evidence. If we can move on to the next slide, additional consequences could be the payment of expenses, including attorney's fees, informing the jury of the failure to supplement, and the court has broad discretion, as always, in the imposition of sanctions. So in those circumstances, we have to be conscious now, as parties and attorneys, of our obligations to make sure that discovery is current right up unto the point of trial. And with that, I'll let Kate take over on timing and completion of discovery.
Now, with respect to the timing and completion of discovery, there are a few important changes. Now, as I mentioned earlier, parties can only seek written discovery and depositions after the party served its initial disclosures. Now, with respect to the actual completion of discovery, it's important that the court rules now place a discovery completion date. Before, it used to be there was a discovery cutoff date and you could conduct discovery up until the discovery cutoff date. Now, the court rules say that they want discovery to be completed and received in time before discovery closes. Now, this implies that it's now a discovery completion, not initiation date. So if we want to submit second set of interrogatories, granted now they're limited to 20 interrogatories, so it might be a little bit problematic, but say we want to submit additional discovery requests, we have to do it at least 28 days before the close of discovery so that there's enough time for the other side to provide their answers before this new completion date. The same with depositions. Depending on who is going to be deposed, we must schedule depositions at least, or provide the notice at least 10 to 14 days before discovery ends. Now, the scope of discovery is still liberally construed in the state of Michigan. The courts may control the scope, order, or the amount of discovery as long as it complies with the court rules. Now, we still don't have to produce privileged matters or documents or materials that are protected by the work product doctrine unless there's a substantial showing in the court orders us to produce those work product documents. But now it's beyond that and object to discovery or the production of discovery that we believe is, kind of somewhat of a fishing expedition. We now have to prove that the discovery requested is not proportional to the needs of the case. And this is kind of the same standard that's set in federal court cases. Now, in determining what is proportional to the needs of the case, courts take into account the following factors: whether the burden or expense of the proposed discovery outweighs its likely benefit, the complexity of the case, the importance of the issues at stake in the action, the amount in controversy, and the parties' resources and access to the relevant information. So this new rule means that we're no longer be able just to rely upon the standard overbroad, unduly burdensome, or ambiguous objections. We have to establish that the requests are no longer proportional to the needs of the case. Now, with respect to discovery disputes, parties may stipulate or the court may order that the parties submit to a mediator to actually handle discovery disputes. Now, right now, there's nothing really in place as it requires that you go and have a mediator decide these discovery disputes. Now, I don't anticipate that once courts reopen and resume business per usual in the next coming months, I don't think they're going to have the time or effort to establish these mediation programs. But I think in the near future, they will change. I think that courts will start initiating or requiring parties to submit to a mediator rather than judges being bogged down with discovery disputes. There's nothing more, well, according to several judges, there's nothing more frustrating than dealing with parties that can't resolve discovery disputes. So I think a lot of these judges are going to delegate the task of resolving discovery disputes to someone else. They may be retired judges. We really don't know at this point. I know there's a couple judges in Wayne County and Oakland County that do require you to see a retired judge to decide these discovery disputes. But right now, that's all we have to base these court rules or the likely outcome of these court rules on is just the fact that there are a few judges that require you to go see retired judges. Now, courts can also require experts to be appointed to handle complex discovery disputes involving ESI, which Rick is going to address in a little bit more detail.
Thank you. Electronically stored information, or now the codified acronym of ESI, covers a kind of a huge vista of information. If we think about it, not just the emails that so often are problematic, but likewise records stored in the cloud, accounting records, corporate records, things that we may not even think about that have been stored away electronically for reasons of space, reasons of expense, and which now may have to be recalled, examined, and produced. So to meet what the courts perceived as an issue specifically involving electronic stored information, specific court rules have now been codified and issued to address that information, that category of discovery. But in essence, all it's done is extend what were always the obligations of parties in discovery, specifically to ESI. One difference is the possibility of an ESI planning conference. This obviously is going to be in a case where significant electronically stored information, significant ESI, is contemplated as having to be produced. Commercial disputes more often than standard personal injury cases, but not always. One can conceive of a product liability case where if you're dealing with a design defect or a manufacturing defect, emails communicating that within a corporation could certainly be part of that discovery. And recalling that information and bringing up that information for examination, perhaps years after they were generated, presents its own issues, which are probably best resolved in a conference between the lawyers and the judge, and even with the assistance of experts who can talk about the means by which this is going to be recalled, the means by which that information is going to be produced, the expense that may be entailed in producing it. Because as we'll see, that is going to be one of the considerations in not being forced to produce it. Move on to the next slide. The concept of proportionality, again, is applied here as it is in all other discovery now under the amended Michigan court rules. One can conceive of an idea of a scenario where a bank has an issue with regard to a loan policy, and the various loan officers have discussed that in emails. One could conceive that 6 people's emails for 6 months, 3 months either side of a particular transaction could have to be produced. That would be an extraordinary number of emails in even the smallest organization. And that being the case, proportionality is a serious consideration. Does the case truly merit all of that? Then there's the question of expense. Is that expense to be borne by the producing party or by the requesting party? Is that an issue that the judge has to address and address in advance of the actual production so that the parties understand what truly will be the cost of that kind of a procedure? And again, that is something that plays into the idea of an ESI planning conference in a case where it's predictable that ESI will be a significant part of the discovery process. Moving on to the next slide. Courts should and are supposed to, under the new court rules, take control of ESI issues, including this issue of the allocation of expense, which we've already talked about briefly, and limitation on the frequency and scope of discovery requests with regard to ESI. Because requests for ESI information would be ordinarily propounded as requests for production of documents, which are unlimited, it could become a repetitive, burdensome, and onerous task to have to continually respond to requests for produced or after requests to produce electronically stored information in great detail. Not even speaking to the issue of all of those pieces of electronically stored information having to be reviewed in advance of production for privilege and trade secret in the appropriate case. So we have here an issue that, again, lends itself to some significant thought in order to avoid what are probably very obvious consequences and very obvious burdens and prejudices to parties who have to do a great deal of electronically stored information. Moving on to the issue of the failure to preserve ESI, while this is addressed to ESI specifically, the obligation, I think, is still the same as it always was for evidence that could predictably be relevant to litigation. On the should have been sort of standard, if it should have been preserved and it is lost and deleted irretrievably, because as some people have said, email never dies and it never really goes away and it never really disappears. But there is the circumstance where it may become irretrievable because it's been corrupted. The failure to act reasonably to preserve what potentially relevant ESI has a consequence. The courts will address those consequences by comparing the actual loss to the potential prejudice. Now, in this case, it's not prejudice as we often remark in terms of surprise, but more in terms of what's the quality and meaning of the ESI that's been irretrievably lost. Is it where the admission might have been against interest? Is it where the alternative design in a product liability case might have been discussed and might be used to demonstrate that there was a way to avoid the defect? These are significant issues which could be raised even in the absence of the evidence itself as a means of demonstrating real prejudice. And that real prejudice would have to be addressed by the court, and some manner of equalizing circumstances, some manner of sanctioning the party who created that prejudice and protecting the interests of the prejudiced party has to be done. Moving on to the next slide, the question of intent is part of the court's inquiry in evaluating prejudice, in part because it's bad behavior that will be punished. Accidental behavior, much less so, and much less punitive measures will be taken. But intent can be inferred by the manner in which the evidence, the ESI, may have been destroyed, the timing of the destruction, the manner of destruction, whether it's simply that it was discarded versus whether it was washed out of the computer or the destruction of the device. We had an issue recently involving a district court judge who managed to flush all the information that she had stored on her phone right after she was served with divorce papers. That's an indication of how someone would have created an issue of prejudice to the other party by getting rid of that information by resetting an iPhone back to manufacturer settings. That being the case, very often the court's sanctions will include as we've seen before with the destruction or spoliation of evidence or the loss of evidence, a presumption that that information would have been unfavorable to the party that is not producing it but had it in its possession. Likewise, there are additional consequences to the failure to preserve ESI. In this instance, there's still the possibility of a jury instruction, which could direct the jury to presume that the missing ESI was unfavorable. Or, as we sometimes refer to it, there's the possibility of the death penalty. In this instance, either dismissal of the action or the entry of a default judgment in those most egregious circumstances where the intent to prejudice the other party, the bad behavior was done with the idea of changing the dynamic of the litigation by destroying the evidence. And in this case, evidence which at one point might have existed in solid form, but no longer is existing in hard copy and has been truly extinguished, truly discarded, truly gone forever, irretrievably. Then the courts may be exercised to apply their discretion and dismiss or default a party. With that, we hope we have some questions.
Okay, just to remind everyone, we're using our questions window on the GoToWebinar platform. So if you could type in your questions now, that would be great. We'll get to as many as we can here. I do see we have a couple. So the first question is there a means to avoid having to follow the new discovery rules?
Rick, do you want to take that one, or do you want to?
Well, I think we could probably discuss that back and forth a bit, because there is, in fact, a specific rule 2.302F, which or talks about amending the requirements or changing the requirements by either agreement or by court order, even including the disclosure requirements and the general rules of discovery with regard to how depositions are taken and things like that. So would you really consider that a fail-safe for us, Kate?
I wouldn't consider it a fail-safe, given that some courts are still not even recognizing agreements amongst parties. I just try to submit a stipulated order adjourning the initial disclosure date in one of my cases, and the judge said that we were unable to just adjourn that date alone. We had to adjourn all dates. Granted, there was an agreement amongst parties. We treat it as an agreement, but I don't think it's necessarily a fail-safe. I think we still have to front-load a lot of the work in these cases now to comply with the requirements for initial disclosures. And I don't think there's a way to really escape doing more work as soon as we receive a copy of the complaint, given the fact that one way or another they're going to be due very soon.
And I think one of the considerations is, if you have complicated litigation, if you have litigation that's a class action, that's a interference with a commercial advantage, cases where employment cases where there can be extensive records and extensive information that's got to be identified, and at least identified and described, if not produced with initial disclosures, lawyers have to be conscious that they either have to get along with other counsel or get to the court and get an extension, use this court rule to take some of the burden off early on. And it may be that invocation of that court rule on a regular basis is appropriate in order to take away some of the pressure that all counsel are going to be under in terms of the initial disclosures, if not anything else in discovery.
Okay, great. Thank you for that. We do have a few more questions here, actually. As a reminder, if you'd like to ask a question, type it into our questions queue, and we'll try to answer that. The next question is, what will be the impact if there is a rush of case filings to avoid court closings complicated by the accelerated requirement for exchange of information under the new court rules? I don't know who would like to handle that one.
Well, I mean, I don't know if we're seeing that yet. I mean, Kate, is that something that we're seeing now already?
Personally, I know I have a friend that works at a well-known plaintiff firm, and he said that they're filing pretty much all the lawsuits that they have that have not been filed, or not necessarily lawsuits, but all the claims that have not yet been filed as a lawsuit, because they don't know when courts are going to reopen in the delay. They just don't want to take a chance of any of the statute of limitations running while courts are closed during the current circumstances. So I know that once courts resume business per usual, there is going to be an influx of lawsuits being served, an influx of summons being issued. And I think that there's going to be a lot of insurance carriers that are going to get hit harder with these new lawsuits than others. But given the fact that there's probably going to be an abundance of lawsuits filed, or at least the summons served, or issued and then served around the same time, it's going to require that the parties produce a lot more documents faster, given the number of the cases. So I think we're going to soon be in a predicament where we are going to have a very fast turnaround when it comes to production of documents, especially in these no-fault cases where you have to produce a redacted claim file, a privilege log and a payment log right away almost from the outset of the case. It's going to be a lot of work very fast and a lot of front loading when it comes to these cases. So I think that's going to be a consequence of the current climate.
Well, and I guess to go along with that, I mean, I know of at least one office, a personal injury plaintiff's office, that almost on a universal basis files shortly before the expiration of the statute of limitations, almost always. And because of that, obviously there's going to be significant pressure on them to move their files, with courts being in a compromised state themselves. Limited opening. I know that St. Clair County won't hear motions right now until the second Monday in April. So that essentially means no relief in that regard. Filings, anytime we have a rush of filings like we did when we had tort reform, now maybe motivated by these court rules, it'll make it more difficult. And of course, we have the collision of the two events. Obviously, the external events of the coronavirus and the impact it's having on doing business and practicing law and the operation of the courts, combined with these new rules, which everyone is still getting used to. It's going to present a serious problem if these things collide and someone doesn't take a hand to manage it. And that may not be the courts. That may be at the counsel and client level, in part addressing the issue of, do we want to continue with the rules as stated, or do we want to opt out, take advantage of the court rule and get out from under those deadlines, or do we want to do something else that makes this a more manageable problem? And those are decisions that are going to have to be made. Again, all this front loading of basic discovery at the very beginning of the case is going to put a burden on the system, burden on clients and lawyers to act quickly. The demands make them more thorough and, honestly speaking, more onerous.
Okay, we have two more questions, and last call for questions. Please type them into the questions queue. This one has to do with mediation. Are there any changes to the mediation process as a result of the court rule changes?
Case evaluation has changed, but not very much. At the negligence law section seminar, There was a discussion of that. We frankly didn't have time to do it justice within our time frame here. But really, they've not been significant changes. I wish we could discuss that in more detail. But there was some controversy as to how mediation case evaluation would be addressed under the new rules. They tried to leave it alone as much as they could because there was no consensus. But there are some minor changes that probably have to be addressed separately and in more detail, even though they're minor.
Okay, fair enough. Our last question, and I don't see any others in the queue, so this will be our last question, has to do with ESI. You mentioned email during the ESI segment, but aren't there other types of ESI litigants need to be concerned about?
Absolutely, because we have corporate records that are stored and all kinds of records stored in the cloud. All of that would be considered ESI. Email is just perhaps the most obvious and the most likely to show up even in an ordinary, straightforward personal injury case. But the potential ESI for the storage of design information, construction records, including bulletins and contract amendments and design changes, all of that 3 or 4 years later after the building's built may all be stored in the cloud and have to be pulled up and restored when the concrete starts cracking in the foundation. And did we change the requirements and use this grade of concrete versus that grade of concrete in the poured foundation? Those are the kinds of things that, yes, we are going to find lots more than email to discover as it's electronically stored and as technology progresses.
I think one that's always an important one to address is surveillance video footage. I know that there's so many systems that automatically overwrite themselves after a certain number of days. So that's a big one that usually becomes before the court quite a bit. I think that's an important one to remind clients of if you have individual named insureds that, you have the duty to preserve any surveillance video footage of any incidents known that take place on their premises. So I think those are something that's important takeaway when it comes to ESI is just reminding individuals that we still have a duty to preserve if you think that there could be a potential lawsuit down the road.
And beyond that, there may be ESI that's stored by a non-party that would be still subject to discovery and still subject to investigation, but that still has to be somehow addressed in some kind of discovery approach. And hopefully the non-party in possession hasn't destroyed it before we get to it. As Kate said, with the continually taping over of surveillance video. So, that presents an additional issue.
Absolutely. Okay, well, I don't see any other questions in the queue, so I will go ahead and wrap things up for today. Just when you log off, you will be presented with a pop-up survey. We'd really appreciate you taking a minute just to complete that. We really also value any topic suggestions you have for future webinars. We take those to heart, and it really helps us develop our programming. So please include any thoughts you have on that front. The other thing I'd like to do really quickly is remind everybody that today's recording session was recorded, and that recording will be on our event page at the bottom. Actually, we'll have it in 2 locations on that page. So if you have a colleague that missed this program, feel free to direct them there or share that link, and they'll be able to take advantage of that recording. Lastly, we also have, as part of our Torts and Litigation Practice Group content, the Litigation Defenders blog that we maintain has a lot of good information on it. A variety of different cases are covered and matter types are covered. So we encourage you to go there. You can easily enter your email address and alerts will be sent to you when new content is posted. So with that, I'm going to take just this final opportunity to thank everyone for attending. On behalf of Rick and Kate and everyone here at Plunkett Cooney, we wish everybody nothing but the best as we kind of deal with this unprecedented situation with COVID-19. we're all trying to do our best and figure it out. And just know that we're here for you. And if you need anything at all, please just contact us, and we'll see you down the road. Thanks, everybody.
Thanks, everyone.
Hi, John Cornwell, Untitled Chapter.